for Bass.
Thank you, Mr Speaker.
Without notice, are there any questions? The Honourable Deputy Leader of the Opposition.
Mr Speaker, my question is to the Minister for Finance. The Minister will be aware that foreign debt has jumped today to $180 billion, the highest on record, an eightfold increase on the foreign debt of $23 billion Australia owed overseas before Mr Keating got his hands on the Australian economy. Is it a fact that Australia's foreign debt puts a premium on interest rates paid by each and every Australian, including home buyers, as a result of your government's wanton mismanagement of this problem?
The Honourable Minister for Finance.
Just to correct your question, it is not the highest foreign debt on record. Thanks very much. It is at least 3 percentage points of GDP. It is at least 3 percentage points of GDP lower than its highest point. And another thing that you might have actually also pointed out in the course of your remarks, that the debt servicing ratio related to it as a percentage of GDP is down from something like 20% in the late 80s down to about 11.2, and in fact fell over the course of the last quarter. So you need to get those couple of points firmly fixed in your mind. I noticed that today you decided you'd go out with a variant of this, and when you were quizzed on the doorstop, despite what the Treasurer had to say about these matters today, in which you attempted to portray this position as follows: the worst net foreign debt position Australia's ever had. Wrong, of course. That's $10,000 for each man, woman and child. It represents, in human terms, if you break it down for each person, $10,000 worth of debt that Australians... The journalist comes on, but they haven't incurred the debt. They don't have to pay it back. If you break it down, if you want to try and humanise the figures, the variant humanising figures, according to the opposition spokesman...
The Leader of the House will resume his seat. The member for Northern Territory will withdraw that remark. And I warn the member for Northern Territory, his constant interjections will not be tolerated.
He's definitely expendable.
Honourable Leader of the House.
Humanising the figures. He says that this is his variant of humanising the figures, to go around and frighten the life out of every man, woman and child in the country by telling them they've got $10,000 worth of debt. It's like me going to the member for the Northern Territory who's just paid off his mortgage and has no mortgage, point out that the Minister for Employment, Education and Training has just taken on a $100,000 mortgage, and we said we're going to average it. Whether or not you're responsible, you've got $50,000 each. That's your variant of humanising it. It makes about as much sense as going around and doing that. Now, the simple fact of the matter is that this, of course, is a debt which is carried by the private sector by and large. That and from the government's point of view, about $7 billion worth of the 180 is carried by the Commonwealth Government. And which is a loan of the Commonwealth Government. And the
Deputy Leader of the Opposition. The Deputy Leader of the Opposition will cease.
So you are completely wrong in those propositions that you put forward. The only relevant measure as far as the Commonwealth Government is concerned is what is carried effectively by the Commonwealth in its own operations, not by Commonwealth business enterprises or state enterprises, all of which, of course, carry it against their assets. So you're completely wrong on that. You can't read your figures properly. What is actually carried by the body that at least in the course of the year is responsible to the taxpayer is $7 billion. So it's a nonsense proposition to go around talking about $10,000 for every man, woman and child in your stupid scaremongering. And
I warn the member for Barara.
But it's also even more reprehensible to wander around the place talking about $10,000 for every man, woman, child when you oppose the only effective measures that have been put in place to deal with this problem. Firstly, by moving the Commonwealth budget into surplus, which we are in the process of doing, resisted manfully by yourselves. And secondly, by putting in place the only effective savings arrangement for private savings that's been put in place in this country by the Commonwealth Government ever. And you oppose it. You oppose it. You have no answers on that one. No answers on that one. And as far as, well, we're in the process of getting it in place. The extent Oh, a big horse laugh.
Order. The Deputy Leader of the Opposition.
It's got a 3% further to come, as you know, from what's been negotiated with the business community. And on top of that, of course, there is the contribution that we'll be making to match savings that individuals make themselves. The extent that it's threatened at all, and that's precisely the point I make, the extent that it is not in place is only the possibility that you might get elected and knock it over. Now, every single sensible economist in this country, every single financial advisor that you can care to name, every one of them has signed up to this as the most practical way of dealing with the necessity to get up to speed our private savings in this country, get the necessity to bring up to speed our domestic savings so that we're not so dependent on foreigner savings. Everyone has signed up to that except you. Now, you are the opposition spokesperson on Treasury matters. You have been for 3 years. You have not come up with an economic policy in 3 years. You have not come up with an answer on savings in 3 years, or your finance as well. So it's finance or Treasury spokesman for the last 3 years. So the whole lot on the development of policy.
The Deputy Prime Minister will resume his seat for a moment. The member for Mayo will withdraw that last comment in the same way as the Honourable Member for Northern Territory was required to do the same. Honourable the Deputy Prime Minister.
So you have been responsible for devising an economic policy for your party for the last 3 years. You've not done it. You've not produced a savings alternative to the superannuation propositions that have been put in place. You haven't been decent enough to sign your own party up to it, even though it has virtually now the unanimous support of the business community and the financial community, virtually the unanimous support of that. You are incapable of signing your party up to it. And you come in here and expect us to take seriously questions like the one that you've just raised with us, given the source from which it emanates. Well, your position is reprehensible. Your tactic in getting out there and trying to frighten the average citizen by that nonsense notion that there's a $10,000 debt being carried by every one of them is absolutely reprehensible as well.
The Honourable Member for Melbourne.
Thanks.
Before I call the Honourable Leader of the National Party, if the member for Sturt and the member for Melbourne want to play a bit of one-on-one, I will assist them by allowing them to leave the chamber. Otherwise, you sit there and you listen under the provisions of Standing Order 55. The Leader of the National Party.
Thank you, Mr Speaker. My question without notice is directed to the Deputy Prime Minister and Minister for Finance. Will the Deputy Prime Minister condemn the line of argument adopted by the Leader of the Government in the Senate who attacked counsel assisting the Marks Royal Commission on the basis that she was related by marriage to the Shadow Attorney General, Senator Amanda Vanstone? Do you accept the fact that people who are in any way related to politicians have a right to be appointed on merit without in any way being tarnished by the fact that they happen to be related to a politician? Will you or will you not reject Senator Evans' outrageous slur?
The Honourable Leader of the House.
Firstly, let me say, obviously I absolutely accept the right of any Member of Parliament's spouse to hold any position of authority within the Commonwealth or within the state sector or anywhere you care to name. In fact, Mr Speaker, it is most important that that should be the case. The question arises, of course, in any particular set of circumstances as to whether or not the particular position happens to be appropriate in the context of what it is that the issue is that it is that you are dealing with. Nobody's accepting, Senator Evans did not challenge the right of Ms Vanstone to be a judge, to be a QC, to be whatever the legal profession entitles her to be. That's entirely appropriate. The question is
member for Flinders and a member for Gippsland.
The question is whether or not it is appropriate that a person in that position serves in a particular context. I mean, there is a legion of judges, lawyers or whatever who are excluding themselves from court processes every year, because some element of it might in some way or another relate to the possibility of the appearance, not the actuality, the appearance of compromise. Now, this is not a counsel assisting a royal commission. It's not a permanent position. It is not a job that you hold for life. It is a job that is there for temporary purposes, and many people can fill that position. There are numerous barristers available around the Commonwealth and in Western Australia to serve in that position. The question arises as whether or not in that highly charged situation, no matter what levels of integrity there may be in the person concerned, which may for all intents and purposes be very high indeed, whether it is appropriate in a highly politicised Royal Commission as this one is, and from its very origins, a person ought to serve who has a relationship with somebody actively engaged in the political process. That is what Senator Evans called into question. And I would have thought that that was just one of a number of factors that any person placed in that sort of situation would want to consider. On the one hand, she has a sister-in-law here in this place and outside in the community, virulently advocating various positions in relation to the conduct, the existence, the creation of the Royal Commission, and she chooses to serve in it. Now, that does not go to any criticism of the way in which she may have conducted herself in the course of the Royal Commission. It is a question of appearances. And I thought a most dignified statement on those matters, was made by David Smith this morning on the AM program, whose refusal to see his absolute determination to stand by parliamentary privilege and cabinet confidentiality as central features of decent democratic institutions in this country. His refusal has been now reported to the State Attorney-General for action against him, and was queried about these matters and is obviously a person most directly concerned with the progress of the Royal Commission and most directly reliant upon fair treatment in the case of his own person, what he had to say about it, a person directly affected by it. And what he had to say was not to call into question the integrity, dignity or whatever of Ms Vanstone. What he said...
Order.
I'm talking about David Smith. And what he said... And what he said in these circumstances in which he finds himself, a person personally affected by the political processes associated with the Royal Commission and now its legal processes, is that he does not have confidence with the appearance of the situation in which a person who is related to clear political opponents is there as the counsel who in technical terms is trying to put him in jail. Now, I would have had a bit of note to take of that, I would have thought, by anybody who is concerned about appropriate political processes anywhere. And so it is in that context that I think the questions can be legitimately raised, not in connection with the integrity of Ms Vanstone at all, but in connection with the politics and the appearance of fairness. The appearance of fairness in this process, and it was entirely appropriate for Mr Smith, a victim, to raise that this morning, and the Leader of the Opposition and the Leader of the Government in the Senate to raise it yesterday.
The Honourable Member for Werriwa.
Thank you, Mr.
Welcome to the program.
The Honourable Member for Moncrief.
Thank you, Mr Speaker. Mr Speaker, my question without notice is to the Deputy Prime Minister. Deputy Prime Minister, I draw your attention to the fact that the opposition has never attacked High Court Justice McHugh, who deals also with political issues in a sometimes highly charged atmosphere, on the basis of his family relationship with the Minister for Consumer Affairs. How can you justify Senator Evans' attack on the professionalism of counsel assisting the Marks Royal Commission on the basis of her family connection? And I remind you, he said it was the family that prays together, P-R-E-Y-S, her family connection to the Shadow Attorney-General. How will Senator Evans' comments encourage more women to enter Parliament or seek to rise to higher positions in...
Order. Those on my right. Order. Member for Moncrief has the call with a question.
How will Senator Evans' comments encourage more women to enter Parliament or seek to rise to higher positions in public life or the professions?
The Honourable Deputy Prime Minister.
Well, I would have been most surprised if Senator Evans' objection, as indeed mine, as I expressed in answer to the previous questioner, would have applied exclusively in the case of it being a Ms Vanstone we're dealing with rather than a Mr. I mean, the point's got nothing to do with the gender of Ms Vanstone. It has everything to do with the familial relationship, that's all. Now, I acknowledge the point that you make about the opposition not objecting to the relationship between the two, but of course it would be incumbent upon the High Court judge that if in any set of circumstances he thought that there was an element of that relationship which impinged upon his capacity to consider a particular case, well, sure, a particular case, then he would exclude himself from it. And then, and likewise, it would apply to judges, many of whom are married to solicitors and barristers and who from time to time have personal relationships, or who may have a friendship, or who may have a friendship or an association that is made with is with a person whose case could conceivably be impinged upon by a case that is before the judge or the particular lawyer or barrister or solicitor. They exclude themselves. It's not an unusual thing. It doesn't go. The comments the comments that I made about the position of Ms Vanstone don't go to her appropriateness to be a QC, to be a barrister, to serve as a judge. It goes to the question of whether in a highly politically charged Royal Commission, in which now various members of Parliament seeking to uphold the rights of Parliament and uphold the rights of Cabinet confidentiality are now being referred to the Attorney-General in Western Australia for prosecution. So it's a most intense political atmosphere, and the individual concerned has raised, directly concerned, and who may go to jail for it, of course, if it's taken through to a charge of contempt, says that he feels uncomfortable with a situation in which there is a person related to another individual who is a spear carrier for the Liberal Party in the Senate, in the case of Senator Vanstone. And it doesn't go, and he did not raise at all, did Mr Smith, not at all, whether or not her conduct was in any way reprehensible. It had nothing to do with that. It was all to do with appearances. And as far as that is concerned, I think that he raised his comments in an entirely appropriate way, and he has a point.
The honourable member for Lyons.
Thank you, Mr Speaker. My question is to the Minister for Social Security to advise the House what action is being taken by
Flinders.
I asked the Deputy Prime Minister simply, and I ask him to give us a straightforward yes or no answer. Do you support... Order. Do you support the cowardly and unwarranted personal attack on a woman because she is related by marriage to Senator Vanstone, the senior counsel assisting the Royal Commission? And in particular, do you support the words used by Senator Evans that the family that prays together, spelled EYS, stays together? Yes or no?
Honourable Deputy Prime Minister.
No, you can ask the questions as you choose, and I'll choose to answer them the way I intend. Thank you very much. Very much. As far as I'm concerned, I believe that the situation, in terms of its appearance, and not in terms of Ms Vanstone, represents a grave problem. And as far as this Royal Commission is concerned, and I'm not going to give you yes or no answers, my friend. You have the privilege to ask lengthy and tendentious questions, and I'll choose to respond with the same privilege. Thank you very much. Now, let me go to these statements, because I think these views of David Smith sum up my views on this matter exactly. Since you've asked for my views, I shall express them. In which Smith is being interviewed by McNamara, and the introduction. The thing goes this way. Later he told John McNamara that counsel assisting the Commission, Adelaide QC and Vanstone, should consider withdrawing from the inquiry. Mrs Vanstone is the sister-in-law of the Shadow Attorney-General, Senator Amanda Vanstone. Smith, I don't think in this situation, where the person responsible for deciding the order of witnesses, what witnesses are called and what questions are asked, has a close connection to someone in the federal arena. So you're concerned, says McNamara, about the appearance of propriety. There are a number of issues like that that have concerned me about some elements of the Commission, and he goes on. And McNamara, Anne Vanstone is an Adelaide QC. She's well respected, I understand, in Adelaide legal circles. What is wrong with her appearing in this commission as one of her colleagues did, Brian Martin QC from Adelaide, doing the WA Inc. Royal Commission as it was called? Smith. I know nothing about Mrs Vanstone's qualifications or background, but I think when you're handling such a sensitive political issue, there really has to be a rule that justice has to be seen to be done. I just put it to you that if the sister-in-law of one of the parties was involved in deciding what order witnesses were called and what questions were asked of those witnesses, that people might, is that appropriate? In my view, it's not. Even if you felt that she could accept the appointment initially, I actually believe that when the public statement started to emanate from her sister-in-law, i.e. Senator Vanstone, that she should have either told the sister-in-law to pull her head in or she should have reconsidered her position. Now, that was David Smith's position. And I agree absolutely with David Smith's position. I think I'm being entirely relevant, Mr Speaker, on this matter. I'm asked a series of questions as to what my opinion is on Senator Vanstone's situation, Gareth Evans' opinions of it, and I am answering them in the way I see fit, and they go right to the nub of the issues that are involved here. Now, there are a series of problems now with the way in which this Royal Commission has been presented, which makes it even more important that the position of propriety appears to be done as opposed to simply is done. And that goes to the way in which witnesses have been called, as David Smith said. We have yet to hear, for example, from the people who drafted the petition. This is now 2 months in to the Royal Commission. You'd have thought that a few facts would have been established to start off with. So much so that Mr Halden, one of the principal persons, has finally had to go and present his evidence to the bulletin. To get a hearing for his evidence, he has to put it in the bulletin, and of course when you sit down and read through that evidence, it casts an awful lot of things in a very different light. And he has not been able to get himself on to be heard. When and all this nonsense about they will be called, don't you know that a Royal Commission, you don't get one shot at witnesses. You can come in persistently through the period of a Royal Commission. You can be recalled. I mean, they can have you on day 1 and have you on day 20. They can have you on day 55 if they wanted. So it would have been entirely possible. It would be entirely possible for them to have had, and appropriate, I would say, to have had the people who put in place the petition first up. There isn't actually. It has not actually been factually established before the Commission. It has not actually been factually established that there ever was a petition. Because no one who's been associated with it actually has gone in and said there was. And we're now into about the 2nd month of it. So there is a problem for people who look at the processes of this Royal Commission. And the problem goes, of course, to the original political origins of it, rightly described by Laurie Oakes this morning as outrageous. Those political origins of it, and pointed out by Henderson yesterday, in the Gerard Henderson, pointing out with absolute clarity that this is the sort of petition, this is sort of commission that Malcolm Fraser was invited to address and rejected it outright when he was invited to go down this particular course, because he had a bit of a sense of propriety around the place before the Liberal Party descended. And so the question comes, in this highly politically charged atmosphere, what do you do to establish a decent regime of political propriety associated with insofar as you can go? And I think that David Smith's questioning of that, I think Senator Evans' questioning of that is entirely appropriate.
The honourable member.